Welcome back, everyone. Today I'm going to be reviewing a fascinating book that I read. It's called The Cases That India Forgot, and it's written by Dr. Chintan Chandrachud. This book is about 10 cases that were forgotten by the people of this country, but they ought not to be forgotten because they are really landmark cases, and some of them ought not to be forgotten because in these cases justice was not delivered. So the author of the book is Dr. Chintan Chandrachud. He is an associate in a firm in London, and he has his doctorate from Cambridge University, UK. The book has been divided into four parts. The first part talks about political cases, and the first case that the book talks about is Keshav Singh case. Now, there was this case against Keshav Singh in the Legislative Assembly of UP, because he had published some pamphlets that were in a way derogatory to one of the sitting MLAs of that assembly. MLA was from the Congress party, which was also ruling at that time. So he distributed those pamphlets, and the assembly was not happy about it. So what the assembly did was, the assembly summoned him for the breach of the privilege of the house, and then sent him to a week custody. Now, just on the sixth day of his custody, his imprisonment was challenged in the Allahabad High Court, because on the grounds that the assembly had no such powers to send someone to jail. Now, Allahabad High Court agreed to this and ruled that the person be immediately released, but he was not released. Now, because this was something that was about the privileges of a member of the house, the whole house became very upset, and the two judges that had ordered the release of this man, Keshav Singh, were also held to be in breach of the privilege of the house and were summoned inside the house. Now, these two were the judges of both of them were the judges of the Allahabad High Court. They both were also summoned. Now, what happened was that it became kind of a constitutional impasse where two institutions were fighting with each other. Now, also, these two judges, what they did, they filed a petition in the Allahabad High Court that this order, that they be escorted into the house, this order that was passed by the house, should be struck down because it was illegal, and the judges were acting because it is not legal for the house under Article 311 to pass strictures or even comment over the conduct of any judge of the High Court or the Supreme Court. So what happened was that they filed this petition in the Allahabad High Court. But now, if Allahabad High Court judges also had this another problem. Now, if they heard this petition against the house, then all of the other judges who will hear the case, any two of them or three of them, if they hear this case, they will also be by the house again, because there is already a precedent of two judges being held into this contempt of the house. Now, they had to choose what to do. There was one advocate. He suggested that the whole court, except these two judges who were petitioners, should sit collectively and rule over the legality of this notice from the house. This was accepted, and the whole court sat, except these two judges who were petitioners. So the whole court, around 27 judges, I think, sat and decided that these notices were illegal. They did this because it may be possible to arrest maybe two judges for the government, but they can't arrest the whole High Court, So this happened. Now, all of this was going on, and the house also budged, because now the whole High Court was standing in unity against the house. But still, they wanted that this Keshav Singh, the person who had published these pamphlets, and these two judges, they should apologize for the breach of the house privileges. But if the judges went there and apologized it would uh, impact the impartiality of the judiciary and the independence of judiciary. They didn't want to go there. So what happened, that this case went to the Supreme Court, and Supreme Court decided almost in favor of the High Court that High Court was within its power and jurisdiction to strike down the notice and also that sentence that was passed by the House against Keshav Singh. So I have told the brief summary of this case. Please read the whole chapter in the book. The second case that is about Minerva Mills. Minerva Mills versus Union of India. This case challenged nationalization, but this case also challenged many important constitutional amendments that were passed by the Indira Gandhi government during the emergency. So there were amendments like there was amendment to the amendment article itself, the article in the constitution that was 368. Now 368 allowed, earlier it did not say clearly that the whole constitution can be appended and amended, but now the amended article 368 said that the whole constitution, even the whole constitution and any each and every part whatever the parliament wishes can be amended. Now this challenge was mounted to this article of the constitution and also another article, that is 31C, that is that if some law is being enacted to to give effect to the directive principles of state policy, then it cannot be challenged on the ground that it was going against fundamental rights. This case was argued by the legendary Nani Palkhiwala, and he said some legendary lines. He said that Parliament could not enlarge a limited amendment power into a unlimited amendment power, and this was the main argument that was accepted by the court, and the basic structure doctrine was saved. And because this basic structure doctrine was very very fragile when it was laid down in the Keshavanand Bharati case, where so many judgments were written and it was not even clear that what exactly forms the part of the basic structure. So here the court could have done something that would have even nullified the effect of the basic structure doctrine, but it did not happen so, and that is why it is one of the most important cases that happened about saving the polity of this country. The third case is about Rameshwar Prasad versus Union of India, and this case is about the coalition government formation and also the horse trading that used to go on and still goes on, about buying MLAs and luring MLAs into forming a government. So this case was about the elections in Bihar. In Bihar, the elections happened, but no party got a majority. So the coalitions were being formed. What happened was this: that NDA was almost nearing the completion of the majority and was going to stake their claim to forming a government maybe the next day or the day after, means in some time. But what happened was this, that the government of India, based on the report of the governor, called an emergency meeting at 11, emergency cabinet meeting at 11, and rectified the imposition of president's rule in Bihar. And also the president, who was Mr. APJ Abdul Kalam, he was out of India and he was in Moscow in Russia. He was woken up at midnight so that he could sign this proclamation of president rule in Bihar. So all of this was happening, and all of this happened, and the assembly was dissolved and fresh elections were also announced. But then these parties had also started to campaign for these elections, but had also approached Supreme Court saying that this notification from the honorable president is illegal. The Supreme Court heard this case and said that yes, it was indeed illegal on the part of the president to act solely on the basis of the governor's report, which was also not based on any substantial evidence that the horse trading was going on in fact. So the Supreme Court said that the president's notification was illegal, but it hugely censored the governor, and the governor had to resign. There were also allegations of him being from the Congress party, which was ruling at the center, and he didn't want any other government except from that of the Congress to be sworn in, right? So the Supreme Court also chastised him for acting in this partisan manner, and also laid down some of the precedents that were already there, that if there is some party that has got the majority, they will be invited to form the government. If there is no such party, then if there is pre-poll alliance, then they will be asked. Otherwise, the single largest party should be asked. In this way, the Supreme Court clarified what the governor ought to do, and the governor really does not have lots of discussion after this case and another Bumai case that was delivered. Now, the second part of the book talks about gender. Now, the fourth chapter is about a case that is Tukaram versus State of Maharashtra. There is a girl called Mathura, and she was in love with a man called Ashok. So she married him, but her brother did not like that she married him. So he went to the police station and lodged a kidnapping complaint against Ashok, who was her husband now. This case was being sold or whatever, investigated by the police in the police station, and for the same reason Mathura was summoned to the police station, and all of these people, Ashok, Mathura, and her brother Gama, all of them were there. It was night time, and the constable, I think he was the head constable who was investigating this case, wanted to go home at night and told these people to return with some documents after some days. Now this head constable went for the night, and he went to his house, but there were another two constables, and the name of these constables is Ganpat and Tukaram. What these people did, they asked all of the other people, this Ashok and Gama and some other people, to go out. But when all of these people, and they also asked Mathura to go out, but when all of them were going out, they asked Mathura to stay inside the police station. Now what happened, that Mathura stayed inside the police station, and all of these other people who were accompanying her stayed outside in the veranda of the police station. When they went outside, the electricity connection went off inside the police station, and the doors of the police station were also locked. While all of this was going on, these two police constables, that is Tukaram and Ganpat, they both took advantage of all of this. Maybe they did themselves all of this, and Ganpat actually raped Mathura, and Tukaram tried to rape her, but he was in intoxicated condition. So that is the reason that maybe he could not do penetration, and that is the reason that he was later convicted of only outraging the modesty of a woman, whereas Ganpat was convicted of rape. But this happened quite later on. But let's talk about what happened before that. There's this test which is quite derogatory to women. It's called two fingers test. In this test, literally two fingers are inserted inside the private parts of the woman to know if one, she is sexually active, two, was she sexually active just before some time, so that penetrative rape or sex can be ascertained. Now the session judge who was hearing this case at the district level acquitted both. The sessions judge said many things which were patriarchal, stereotypical, and also very derogatory to women. He said things like that she displayed no resistance, there was no struggle, there was no scream, and there were no injuries or scratches on her body. And because of this, he concluded that this was something that was consensually done by Mathura with Ganpat. And uh, doctor also said in this case, the doctor who examined her said that she was habitual of sex. And um, but the question arises, uh, the question that arose was that why did she allege a rape if it was consensual? The court answered that it was because she wanted to sound virtuous in front of her lover, who was Ashok, and also some of the other family members that were there waiting for her. Then this case went to the High Court, and um, High Court actually overruled the judgment of the Sessions Court and said that Mathura's account was pretty credible, and it also ruled that there is difference between consent and passive submission, and it convicted Ganpat of rape and Tukaram of outraging modesty of a woman, and sentenced Ganpat to 5 years of imprisonment and Tukaram to 1 year of imprisonment. Um, the Supreme Court, however, overruled the judgment of the High Court and reverted to the Sessions Court judgment. It said that all of those derogatory things that were said by the Sessions Court, it said that there was absence of injuries, and that implies consent. And the other thing that they said was she should not have, meekly allowed Ganpat to satisfy his lust. And the other thing that they said was that, uh, which was implied by them, was that if you say that this is a rape, one, there has to be clear no said to the person who was doing this to her, and also there should be some violence involved, that there should be some resistance, or she should try to hurt the person who's trying to do this to her. So in this way, Supreme Court wholly acquitted both of these people, and also then this case was not reported for almost a year, but then four scholars came across this case and they wrote an open letter to the Chief Justice of India, Justice Y.V. Chandrachud. And these one of these scholars were also Upendra Bakshi, and they said that human rights and constitutionalism is at stake. Accused may be liberated because some better reason for his acquittal may be found, but these patriarchal and these derogatory reasons given that just because she did not resist means she had consented to this cannot be the reason that these people are acquitted. And also they said that because the Supreme Court is the highest highest court of the land, it will also impact so many other Mathuras, so many other women who have been subjected to such kind of sexual violence, and they will not be able to secure conviction against these perpetrators, just because they will be able to prove that she does not suffer any injury, and that is why it was consensual. um, and there were so many demonstrations, so many protests, and after that the ruling in this case was never changed. The justice in this case was never delivered, but it forced the Congress government to examine the laws on rape, and ask the law commission to suggest recommendations that can make these laws better. The recommendations were that if a woman alleges that she has been raped, and the the intercourse has actually happened, and she alleges that it was without her consent, then it should be presumed by the court that it was actually a rape, and it should fall upon the the alleged rapist to confirm that, to prove that it was instead consensual and it was not forced. The other was that the age of consent should be increased from 16 to 18. What actually happened was that the law that was accepted by the parliament was that the punishment for rape was increased from 5 years to 7 years. The minimum punishment was now made to be 7 years, and it was also made an offense to disclose the identity of a person who's a victim of rape. That's all that was done. The fifth case that we talk about is R.D. Bajaj versus KPS Gill. Now, KPS Gill, you may know, is a very celebrated police officer, and he has served as DGP of many states. Now, this is a very shameful case because of the reason of the facts of the case. There was a party that was organized by an IAS officer, I think, in Chandigarh, and this was attended by lots of powerful, influential people who were residing in Chandigarh. And Miss R.D. Bajaj is an IAS officer, and Mr. KPS Gill is an IPS officer, and Miss R.D. Bajaj is an IAS officer. They both were there. While this party was going on, Mr. KPS Gill asked Miss Bajaj to come near to her, and she went there that maybe he wants to talk to her about something. When she went there, he asked her to come to sit near to her, which she obviously did not approve of. Something like this happened. When she did not come and sit there, he went towards her and in a way spanked her bottom. He slapped her bottom. Now, this was absolutely derogatory and also something that was sexual in nature. Now, she did not like this at all, and she went to the host of the party, who is, I think, Mr. Kapoor, and complained of this behavior to him. He asked Mr. Gill to maybe apologize or leave the party. I'm not so sure now, but she obviously launched an official complaint so that some action should be taken against Mr. Gill in a way that would actually affect his career, right? Because you cannot be so powerful and behaving in such uncivilized way. This complaint was there and was not acted upon for 4 months by the governor and other administrative authorities. After 4 months, when she was convinced that the governor and other people are not going to act at all, she approached the magistrate so that her complaint can be registered. The complaint was registered, but Mr. Gill then approached the High Court. The High Court ruled that Mr. Gill that all of this was an agenda against Mr. Gill, and that these are all malicious complaints, and and the High Court quashed them. She approached the Supreme Court then, and the Supreme Court ruled in her favor and directed the trial court to complete the trial in this matter. The trial commenced. The Chief Judicial Magistrate convicted him of the offence and sentenced him to 3 months of rigorous imprisonment. Then this was challenged in the Sessions Court. Sessions Court upheld this, his conviction, but now gave him probation, which is that he will now need not, go to the jail, but will have to do some things and report and show that he is behaving properly. So he had to give 2 lakh rupees as compensation to Miss Bajaj. He also had to pay 50,000 rupees as legal fees for Miss Bajaj's case, and also some other conditions were imposed, like he will not be going to the parties and drinking openly in the public, and directions like that. Now, when Mr. Gill also wanted to be acquitted, he didn't want that he should remain as a convict, so he went to the High Court, and later on this also went to the Supreme Court. The High Court upheld the conviction but dropped some of the conditions, like he should not be consuming alcohol in the public spaces, and condition by saying that that it was very hard to implement. Then when it went to the Supreme Court upheld the High Court's decision, and in this way he was convicted, but he's still a very celebrated police officer. The third part of the book is about religion. The 6th chapter is State of Madras versus Shrimati Champakam Durarajan case, and this case is about communal geo, which is about which told about the admission which will be given to certain sections of societies based on caste. If you are a Brahmin, then you will get this many seats. If you are a non-Brahmin, then you will get these many seats. If you are a Muslim, then these many seats out of the total. And this was issued by Madras government, and it was purely based on caste. It was challenged in the court, and the court ruled that it violated fundamental rights under Article 29, sub-article 2, and it also led to the first amendment that happened in the constitution. Seventh case is about Bombay. It was about bigamy that used to be practiced among Hindus. So there was, the name of this case is State of Bombay versus Narasu Appamali. This case involved a law. The law is called Bombay Prevention of Hindu Bigamous Marriages Act of 1946. In this judgment, the Bombay High Court ruled that all uncodified personal laws are immune from the fundamental rights under the Constitution. Now, this case is very complex, and thus I cannot explain the whole judgment to you. The fourth chapter is one of the most important, I feel, because this theme is not covered in other books that I've read. I have not read lots of books on law, so I'm not censoring every book that exists on law. The fourth chapter is about national security. There are 3 cases on this. The 8th chapter is the case of Kartar Singh versus State of Punjab. About national security, the author says that threats to national security, whether real or imagined, are often a trump card for governments around the world. National security is a shield that protects legitimate government action, but it can often be used as a cover for a multitude of sins. This case is about the challenge to the constitutionality of TADA. Now, the first question that was raised before the Supreme Court was whether the government of India, rather Parliament of India, was jurisdictionally capable of enacting this law, by saying that this falls under the defense of India, and the other side was arguing that this falls as a way to maintain public order in the state. So if it fell under the defense of India, then it would be in the domain of the union list. But if it fell under the public order, then it would be an illegal act of Parliament of India and would fall in the exclusive domain of the state legislature to pass any laws to maintain the public order. The Supreme Court in fact ruled that it was related to the defense of India, and thus the Parliament was competent enough to enact this law. The second question was that this law is very draconian, and it also diminished various safeguards which are usually available under general criminal law. For example, say if somebody is arrested under TADA and they give their confessional statement to a superior officer, then it was admissible in court, whereas we obviously know that there are so many tactics that the police uses, mostly torture, to extract a confession by hook or by crook so that the conviction can be secured. But the Supreme Court in the first in the beginning lamented the state of affairs about how people are tortured, and they themselves as judges and before being judges as advocates have seen so much of this torture happening across the country to secure this confession and statements, to secure conviction. But in the end they ruled that because it dealt with terrorism and it endangered the integrity of the nation, so it was necessary. So this is what the author was talking about, how it is a trump card for the government, and this can be used anytime by the government for whatever reasons, the latest case being Pegasus. And the ninth chapter is about Naga people's movement of human rights versus Union of India. Now, this case dealt with the challenge to the constitutionality of AFSPA. Uh, it was challenged in the Supreme Court as well as Guwahati High Court, but these challenges were not heard for a long time. And when it was heard in the Guwahati High Court, one judge stayed a provision which, at I think section 15, which was a license to kill a person. That is, that if you kill a person on the suspicion that this person is a militant, then you will not be prosecuted at all if you are an officer of the state. Now, you also don't have to justify that because of this reason I felt that this person is a threat and so I had to eliminate this person. So this particular provision was stayed by the Guwahati High Court. When it was stayed, and because it was one of the main provisions that gave some teeth to this act, the central government hurriedly went to the Supreme Court and asked and requested the Supreme Court to please hear this case. And the Supreme Court at this point in time was on the vacation, so the vacation judge granted a stay on this judgment of the court. So when the court came back after the vacations, they quite speedily decided this case and decided that that this case now need not to be heard inside the Guwahati, that jurisdiction of the Northeast, because there were so many protests going on in that area, and the Judicial Officers Association of that area had also, come out strongly against AFSPA. So there was little scope of impartiality in this matter. So this case was shifted from Guwahati High Court to Delhi High Court, especially by the Supreme Court, so that it can be heard. Now, this Delhi High Court judgment said that collective security would trump individual rights and liberties, and thus it also upheld these two sections that were under challenge. It also upheld the license to kill section. Then, after 15 years of all these petitions piling up in the Supreme Court, the Supreme Court finally heard this case in 1997, and the same question was before the Supreme Court as well, that whether the Parliament had the authority because it fell under Defence of India, or the state government had the authority because it fell under the public order entry. So the argument that was raised was that AFSPA was a law that violated various fundamental rights of citizens. So the Supreme Court ruled that the Parliament had the authority. I'm not sure about what Supreme Court ruled over how it is legal for AFSPA to be trampling so many fundamental rights that were guaranteed by the Constitution. Another argument was that AFSPA's imposition in disturbed areas was almost like the imposition of emergency, but emergency came with its own safeguards, like there cannot be that Article 20 and Article 21 cannot be suspended even during the emergency and things like that. But when AFSPA is brought into force and disturbed areas are declared, such safeguards are not available. The Supreme Court really did not answer this and said that just because it is not arbitrary or unreasonable, it is constitutional. And by giving the same reason as per the author, the Supreme Court ruled that every section by section, all of these are not arbitrary or unreasonable, and that is why they are constitutional. And also there was this suggestion that was given by one of the councils that this right to kill, this license to kill section that was there in this AFSPA should be at least watered down and should be applied to only people or militants who are armed, and not to the people who are unarmed. But the Supreme Court did not even read it down even this much, so that unarmed people are not shot like that. The 10th judgment is Nandini Sundar versus State of Chhattisgarh, and it deals with Salva Judum case. And this is the case that I was talking about in the beginning, as how Supreme Court's judgment had zero effect on the ground. In this case, the Supreme Court ruled that the special police officers that were employed by the government of Chhattisgarh was illegal. These special police officers, this whole force comprised of militants, Maoists who were surrendered Maoists or were from the local community, right? So these people were really untrained, and they didn't know how to use all the weaponry, and they were maybe not even given the latest weaponry to fight with the insurgents. But these people were taking part in frontline counter-insurgency operations. So it was obviously a threat to their to their life to be untrained and still taking part in such very dangerous operations. So the Supreme Court found it to be unconstitutional that any such force of local civilians be made to do such tasks. But the government of Chhattisgarh only did one thing. They you know changed the name of special police officers to district reserve guards, and they are still making them do all the work that they used to do, whereas the Supreme Court said that these people should be transferred, redeployed to traffic management and other activities that are not very dangerous. But uh, nothing much has changed. So this is the summary of this book, and I quite enjoyed reading this book. Now please don't go on the note that I've just talked about, because all of this, for example, say AFSPA or say TADA, the author explains the whole, from the starting, from the beginning when the law was enacted, why was it enacted, and the author talks quite in detail about all of the impact of these laws in the society, and it would make for an absolutely interesting read for any of the person who wants to read, and it is a must read for law students and lawyers because of the fact that it deals with so many important cases. So this is my book review and summary for this book. I'll be back next Sunday, and I had not posted for last 2 or 3 weeks because we were shifting, and two, I was also engaged in my admission processes and entrance exams. So honestly, I have not been able to finish any book except for the book that I last reviewed, The Story of Great Depression. This book I had read maybe 1 or 2 years ago. So today I read it again and made these notes so that I can summarize it for you. So I'll be back. Hopefully I'll be back next Sunday. Till then, take care, stay safe, and please subscribe, like, and share with your friends. Thank you very much for watching.